We will now start, and thank you for joining this panel discussion dedicated to the prisoners of war. We will focus on three aspects of this question. We will go over legal standards and requirements that apply to prisoners of war. We will also look into the kind of advocacy that a Palestinian NGO named Addameer is doing for Palestinian detainees, from which we can draw parallels and hopefully learn some lessons. And lastly, we will look into implications for the rule of law during armed conflict and the extent to which the accountability of states is emerging. And we will start with Professor Julia Grignon. She is joining from Geneva at this time. Hello, Professor Grignon. I will quickly introduce you. Professor Grignon is an associate professor at the Faculty of Law of Laval University, where she teaches international law, international humanitarian rights law, international refugee law. She's one of the co-directors of the Clinic for International Criminal and Humanitarian Law and one of the co-founding members of the Interdisciplinary Center for Research on Africa and the Middle East. At the Laval University, she's also a member of the Canadian Partnership for International Justice. Professor Grignon is a member of the Scientific Council for the Institute for Strategic Research and Military School in France, and a member of the Board of Directors of the Société Québécoise de Droit International, and I'm sorry I botched this. Professor, we're all very excited and honored that you're joining from Geneva, and we will have you speak for 20 minutes, and then we'll get back to you for a question and answer session in approximately 40 minutes after you've completed your presentation.
Thank you very much. First of all, I would like to both congratulate the organizers for convening this conference and thank them very warmly for inviting me to speak. It is a true honor to be among such eminent panelists and attendees, and I only regret not being able to be there in person in order to also share social moments with you all. Also, I must mention that I'm no more a member of the Scientific Council of IRSEM, as you said, because now I'm a fellow researcher within this institute. Now, regarding the topic, in order to assess the conditions of prisoners of war, captivity, and avenues for repatriation, the prerequisite is to know what the law says about these aspects. It is a task that I have been assigned to, and for doing so, I will first restate who is entitled to the prisoner of war status under international humanitarian law and why it matters. Then I will give a glance of the way they are protected by this body of law and what are the obligations incumbent to the detaining power. And I will finally address the question of their release and repatriation. I must also, beforehand, mention that what I will say is applicable to any given prisoner of war in the world today. So what does international humanitarian law say about prisoner of war? But first, why is this body of law relevant? International humanitarian law has been mentioned during previous presentations in this conference, but still I think it's useful to recall that international humanitarian law is the relevant body of law with respect to prisoner of war because that is the law applicable during armed conflict, a legal classification that is to be applied to the Armenia-Azerbaijan situation during the events of 2020, and that led to the capture of soldiers. So under international humanitarian law, there is only two possible statuses for people who have fallen into enemy hands. Either they are civilians or they are prisoners of war. Prisoners of war are those who were combatants upon their capture. The following question is therefore, who is a combatant in armed conflicts? A combatant is first a member of regular armed forces of a party to a given conflict. A combatant may also be a member of other militias and of other volunteer corps that belong to a party to a given conflict, provided that he or she fulfill four conditions. First, that of being commanded by a person responsible for his and her subordinates. Second, having a fixed distinctive sign recognizable at a distance. Third, that of carrying arms openly. And fourth, that of conducting their operations in accordance with the laws and customs of war. But since those who were captured in relation to the conflict that we are speaking about were members of the armed forces, let's keep it simple. So simply said, all members of the armed forces of a party to the conflict are combatants, except medical and religious personnel. All other persons, unless they have committed a belligerent act and there is therefore a doubt as to their status at the time of capture, all other persons are civilians. There is no in-between status. Now, why is this matter and how are prisoners of war protected by international law? International humanitarian law. Distinguishing between civilians and prisoners of war matters because the law applicable differs depending on their status. One specific convention is dedicated to each category. The third Geneva Convention of 1949 for prisoners of war, and the fourth Geneva Convention of 1949 for civilians. In terms of treatment, the differences are a few, but in terms of status, the difference is big. First, while prisoners of war should not be prosecuted for the mere fact of having taken part in hostilities, civilians may be punished for having taken part in hostilities. When fighting, and as long as they respect IHL, combatants are achieving their duties. They are only doing their job. In return, they may be targeted at all times during an armed conflict. But once captured, they cannot be prosecuted for having done their job. Civilians, on the contrary, are protected against attacks. In return, they are not allowed to take part in hostilities. And if captured, they may be prosecuted for having done so. Secondly, prisoners of war may be retained until the end of active hostilities. Since the purpose of their capture is to prevent them from fighting, it is logical that they should be released only when they no longer represent a threat to the party to the conflict in whose power they are. However, there are special measures for incurably wounded and sick combatants. Those ones no longer pose a threat and must be repatriated to their country of origin. If they are not repatriated, they must, of course, be cared for by the party in whose power they are, and I will come back to this later on. Civilians' internment, on the contrary, even if is also an administrative measure, has to be re-evaluated every 6 months, and they must be released as soon as the reasons that have justified their internment no more exist. So these elements exemplify why the determination of the prisoner of war status matters. In terms of the obligations incumbent to the detaining power, as I said, they are not that different from the obligations related to civilian internees. This being said, prisoners of war benefit from a whole convention, the third one, which is only dedicated to their protection and that contains 143 provisions. I will not detail each of these provisions now, but through some examples, I now turn to specific requirements in terms of conditions of captivity under international humanitarian law. First and foremost, prisoners of war must be treated humanly as any other person who is hors de combat. Similarly, Geneva Convention 3 contains a prohibition of torture and ill treatments and provisions about medical care. But these are not specific provisions. Civilians also enjoy the right not to be ill-treated. Among the specific provisions for prisoners of war, it is possible to mention Article 13 that prohibits insults and public curiosity. exposure to public curiosity can take many forms. The intentional exposure of prisoners of war to insults and public curiosity was a military ritual performed for propaganda purposes already during ancient Rome. It consisted of being paraded in front of the crowds to boost the morale of the party's own population. In modern conflicts, the prohibition also covers the disclosure of photographic and video images, recordings of interrogations, of private conversations, or personal correspondence, or any other private data, irrespective of which public communication channel is used, including the internet. These practices have to be considered as an attack to the dignity and the honor of prisoners of war, and they are therefore forbidden. Article 17 is another specific provisions for prisoners of war. It states that every prisoner of war, when questioned on the subject, is bound to give only his or her surname, first names and rank, date of birth and army, regimental, personnel, or serial number. On its end, Article 21 provides that the detaining power may impose on prisoners of war the obligation of not leaving beyond certain limits the camp where they are interned, or if the said camp is fenced in, of not going outside its perimeter. Prisoners of war may not be held in close confinement except where necessary to safeguard their health, and then only during the continuation of the circumstances which make such confinement necessary. Since their captivity is not a punishment, but an administrative measure aiming at preventing them from fighting, they should be free to move inside the camp of prisoners of war. Individual cells should not be privileged, and this means that contrary to peacetime, requiring individual confinement might be seen as a sanction. Regarding the location of their camp, the Third Geneva Convention does not contain any requirement as to where prisoners of war are to be held captive. And this is quite understandable. Wherever enemy soldiers are captured during the course of fighting, they must be interred in a territory controlled by the party in whose power they have fallen. This even is a guarantee that they can effectively receive the protections provided by international humanitarian law. The Third Convention requires, however, certain modalities for their deprivation of liberty. Prisoners of war may be interned only on land and where the climate is not injurious for them. Also, they must be interned in places which are far from the fire of the combat zone. Article 26 now is worth mentioning because it says the use of tobacco shall be permitted, something that we do not find in any other body of law. Last but not least, Geneva Convention 3 contains provisions relating to contacts with their whereabouts and visits of the International Committee of the Red Cross, the ICRC. This already has been mentioned by the former human rights defender, Mr. Tatayan, earlier today. And indeed, the Third Geneva Convention expressly provides that immediately upon capture, every prisoner of war shall be enabled to write a card direct to his or her family on the one hand, and to the Central Tracing Agency on the other hand. Individuals who have been granted prisoner of war status have the right to be visited by the ICRC. This is a right that they are owed, not a concession that might take the party in whose power they are. In other words, the authorities must allow the ICRC to carry out its activities. So first, the ICRC will register the prisoners it visits. This measure is intended, among other things, to prevent disappearances, since on the basis of the registers that will be established, the ICRC will then organize regular visits to these prisoners. These visits are performed by ICRC delegates, who shall be authorized to go to all places where prisoners of war are present. Inside these places, the ICRC must have any door it asks to be opened, and it must be able to talk to any prisoner of its choice without witnesses, not even a translator imposed on it by any authority. These interviews without witnesses will allow the ICRC to exchange freely with the prisoners, to verify the conditions in which they are deprived of their liberty, that they have not been ill-treated, and more generally, that the guarantees offered by the Third Geneva Conventions have been implemented. These interviews are also an opportunity to collect or transmit Red Cross messages, that is, messages exchanged with their relatives. Among the specific provisions relating to prisoners of war are the provisions relating to their release and repatriation. And this will be my fourth and last point. When should prisoners of war be released or repatriated, and are exchanges of prisoners of war possible? First, regarding release and repatriation. Article 118 of Geneva Convention 3 is pivotal in this respect. According to this provision, and except for incurably wounded and sick ones, prisoners of war shall be released and repatriated without delay after the cessation of active hostilities. As explained previously, since the purpose of their capture is to prevent them from fighting, it is logical that they should be released only when they no longer represent a threat to the party to the conflict in whose power they are. The question then is, what is the end of active hostilities? And what is the effect of the conclusion of a ceasefire on the release and repatriation of prisoners of war? The end of active hostilities is a factual assessment. It does not need to be confirmed by a formal agreement such as a ceasefire. The end of active hostilities does not mean the end of the armed conflict, but the end of active hostilities will allow for some steps to be taken under specific provisions, whereas the general clause of military operations indicates that the armed conflict is completely over. The determination as to when active hostilities have ceased with a sufficient degree of stability and permanence is context specific, and has to be made in the prevailing circumstances of each case by looking at the facts on the ground. Active hostilities may be considered to have ceased when there is no reasonable expectation of their resumption. So if there may be doubts sometimes about the exact moment in time when this obligation starts, that is the release and repatriation of prisoners of war, there is currently no doubt that prisoners of war who would have been captured following the events of 2020 should be released and repatriated. An exception exists, however, for those who are prosecuted or who have been sentenced. They should be released and repatriated once their sentence is done. As I said earlier, prisoners of war should not be prosecuted for the mere fact of having taken part in hostilities. By their signature of Geneva Convention 3, all states in the world have recognized among themselves the right of their regular armed forces to fight in armed conflicts. The logical counterpart of this is that members of these armed forces will not be prosecuted for this fact alone if they are captured. However, like any individual, prisoners of war can be prosecuted. That is, those of them who are suspected of having committed war crimes, for example, may be tried, and all the judicial guarantees of a fair trial must be granted to them. No, and finally, regarding exchange of prisoners. This is not something which is dealt with in Geneva Convention 3. It is therefore not forbidden to proceed with exchange of prisoners of war, whatever the terms of the agreement are. They may be exchange soldier per soldier, rank per rank, all for all, or in exchange of any other matter. I give you the example of Gilad Shalit. Gilad Shalit was an Israeli soldier who was captured by Palestinians. Gilad Shalit was released in exchange of 1,072 Palestinian detainees. Similarly, there are currently ongoing negotiations between Russia and Ukraine about the release of some Ukrainian soldiers, notably potentially in exchange of Viktor Medvedchuk, a Russian citizen. Here is what could be said in 20 minutes about the status of prisoner of war and its consequences for the protection of those entitled to this status during armed conflict. And I'm now looking forward to hearing my co-panelists about the way it could be applied in practice.
Thank you so much, Professor Grignon, for explaining so clearly the complex and complicated legal framework. We'll get back to you in 40 minutes approximately. And right now, our next speaker is joining from Ramallah, Palestine, and her name is Milena Ansari. Milena is an international advocacy officer at an organization called Addameer Prisoner Support and Human Rights Association. Hello, Milena, welcome. Milena, a few words about this organization. It was established in early 90s, and it's a Palestinian human rights organization that works to support and advocate on behalf of Palestinian political prisoners held in Israeli and Palestinian prisons. And their focus is to provide free legal aid to prisoners, advocate for them nationally and internationally, and also work to end systemic violations of prisoners' rights through monitoring, legal procedures, and solidarity campaigns. And specifically, Ms. Ansari's work focuses on submitting appeals, complaints, and reports on behalf of Palestinian prisoners to the United Nations and relevant actors, while also building international solidarity campaigns. Before working at Addameer, Milena was the Right to Education project coordinator at Defense for Children International Palestine. She has developed a good knowledge and practice of international law, international criminal law, and human rights, both on academic and professional level. Milena, you have the microphone, please. Start.
Hello, everyone, and good afternoon, good evening. I hope everyone is doing well and the conference is as successful as expected. Thank you to the organizers, and thank you, Emilia, very much for all your efforts in organizing these panels. And it's very unfortunate that I was unable to attend in person. I was very much looking forward to connecting with everyone after COVID and more than 2 years of no actual seeing anyone in person. So I apologize for not being there in person. I wish it would have happened. And I'm very honored to be speaking on this panel, especially with the two esteemed panelists now speaking. I will try to be as not complicated as possible, but the situation in Palestine is complicated if you want politics to be involved in it. But if we stick to Professor Grignon's international humanitarian laws legal analysis, it should not be complicated at all. But unfortunately, the Israeli occupation, apartheid regime, and settler colonial regime has made it extremely impossible for any states to act in support of Palestinian rights. Apologies, but there is a slide presentation happening, but maybe I'll limit it to a few slides, if that's okay with whoever is on the logistics and technical stuff. So again, my name is Milena Ansari. I'm the International Advocacy Officer at Addameer Prisoner Support and Human Rights Association. For Addameer, we use the term Palestinian political prisoners, just because many of the Palestinians are not partaking in any of the hostilities. Most of the prisoners or the detainees that we advocate for are Palestinian students, females, journalists, civil society actors, politicians, parliamentarians. They do not meet any definition of an active
This is not the big tech panel, but we are experiencing technical issues. All the hope for RIT.
Political affairs or even partaking in military actions, because that doesn't exist in the majority of the cases that the Palestinians we represent. Addameer, just a brief introduction about Addameer. We have a legal unit, which in the legal unit, it's a collective of lawyers that provide free legal aid to Palestinian prisoners held in Israeli occupation prisons, in military prisons, and also in Israeli civil prisons. There is a distinction because, as you might know, the Israeli occupation is practicing a military regime on the West Bank. But for example, in Jerusalem, which is illegally annexed to the state of Israel, because under international law, Jerusalem is not designated as the capital of Israel. There's still no clear side to where Jerusalem stands, but the Israeli occupation has long annexed Jerusalem illegally to its own state. So for Palestinians in Jerusalem, they are tried in Israeli civil courts and not military courts. My briefing now will mainly focus on the occupation regime in the West Bank and military courts and how Palestinians are treated in these courts and how Addameer tries to advocate on their behalf on an international level. So the information I'm bringing forth for you is testimonies that we have taken through the documentation unit, prison visits that we conduct in Israeli occupation prisons, and myself, I'm a lawyer, so I also understand how the Israeli military judicial system works. I don't like to give a lot of statistics and numbers because they change, but the next slide will show general statistics about Palestinian political prisoners. I see that we're still on the first slide, so maybe we can forget the PowerPoint presentation and I can talk as much as I want according to what we've heard. Here are the statistics. In general, there are the total number of political prisoners are 4,000. The statistics are there are before you. There are 4,650 prisoners. 170 are children, 32 are women, and 7 are Palestinian Legislative Council members. These are the Palestinian parliamentarians who are in detention solely for their influential political leadership and position as parliamentarians. The other number that I would really try to focus on is the 600 administrative detainees. So these are the Palestinians who are detained without charge, without trial, based on secret information for an indefinite time. So under international law, administrative detention is not illegal, but it does have specific requirements that should be met. The idea of administrative detention, for how Israel, the Israeli occupation practices it, is to detain someone under the thought that they may impose a future risk to the security of Israel, so they detain them. There is no specific time to how the Israeli occupation orders administrative detention. So we have many detainees who are still under administrative detention for more than years. And these don't exempt any children or women. Currently, there are 2 children under administrative detention, so no charges against them and no trial taking on. I will link both human rights law and humanitarian law. just because the situation in Palestine is, again, complicated if you want it if you want it complicated, but not complicated if it's clear that you care about human rights and the protection of the people. So according to human rights, the deprivation of liberty of children should come as a last resort and for a specific time. But Palestinian children are put under detention, administrative detention without charges for an indefinite time. And also they are deprived of their liberty as a first solution, without bearing in mind any early releases or house arrests or any other methods. With my talk, I will be covering various systematic violations and how Addameer will or does its work in advocacy. But it's important to give you a bit of context. If we go to the next slide, it will talk about international humanitarian law, which is complementary to what Professor or Ms. Grignon mentioned. So out of the 18 prisons that the Palestinians are held in, only one is located inside the West Bank, so inside the occupied territory. The rest of the 17 prisons are all located inside the territory of Israel, which means the majority and the huge majority of Palestinian prisoners are forcibly transferred outside of their occupied territory to be detained in Israeli prisons inside the territory of the occupied power, which means this is a war crime under the International Criminal Court Rome Statute and in general under international humanitarian law. You cannot forcibly transfer an occupied people to detention centers outside of their occupied territory. And this has always been important information and fact that we use in our analysis, because when we report to the International Criminal Court, I'm not sure if you are aware of this information, but last year, the Office of the Prosecutor in the International Criminal Court approved to open the investigations in the situation in Palestine, which means they will be looking into war crimes and crimes against humanity that are being implemented in Palestine. And the forcible transfer of Palestinian prisoners and detainees is a huge aspect of a war crime that is implemented in the occupied territories. Very briefly, I'll talk about how Palestinians end up in prison because it will give you a bit of context and then we can stop looking at the slides, no worries. The Israeli occupation has basically established a full apartheid regime where they exercise legislative powers, judicial powers, and executive powers, which this means they are the law-making power in the West Bank through Israeli military orders, and they prosecute Palestinian civilians in Israeli military courts based on Israeli law. So what it means to be prosecuted in an Israeli military court, it means that the judge is an Israeli military officer, the prosecutor is an Israeli military officer, the law that is used to try Palestinians is Israeli military orders, and the legal procedure of the court are Israeli legal procedures or judicial procedures. The language spoken in these military courts is Hebrew, a language Palestinians are not aware of and they don't know as we speak Arabic. So the documents and all the legal reports and procedures that happen in court, Palestinian detainees and prisoners are completely oblivious or don't know what actually happens. So the role of Addameer as their legal counsel is to try as much as possible to allow them or to have the ability for them to understand that we know we taught you that your right is to stay silent. Your right is to have an assisted counsel at every stage. But the minute Palestinians are arrested, none of these rights exist. One of the units that Addameer has is the awareness unit, where we do workshops for Palestinians, for them to empower them, to prepare them to what happens during detention. It's not like we expect detention or arrest or we want that, but it's basically because no one is exempt from arbitrary arrest by the Israeli occupation, regardless of gender, regardless of age. This is completely not taken into account by the Israeli occupation. and no rights from what we heard about medical treatment or any proper treatment for prisoners is applied on Palestinians. And this is important to note because Palestine is under an armed occupation. So by default, international humanitarian law should be applied on the West Bank. So what does Addameer do? How can we help when the situation is completely against us? By the way, a small important fact, according to Beit Salem, which is an Israeli human rights organization, the conviction rate of Palestinians in military courts is 99.7%. This is a number that's completely bizarre, but it is accurate. Not only because the law is built to maintain Palestinians inside prison, but it is also because Palestinians choose to plead guilty and take a plea bargain instead of having a high sentence inside Israeli prisons. Because the conditions there, I can describe it as much as possible, but as someone who hasn't been in prison, I can only tell you it does not meet any adequate or bare minimum of adequate living for any human being inside these prisons. There is overcrowding, lack of sufficient ventilation, no proper food or efficient food is provided for Palestinians inside Israeli occupation prisons. There is a deliberate policy of medical neglect inside prisons, where we heard under international humanitarian law, the occupying power must, as an obligation and not as a privilege for Palestinians, to provide them with adequate health care. But what we see is stalling with medical reports, stalling with providing the proper medical treatment. And even as Addameer, we also not join forces, but we join collaborative work with other international organizations and civil society actors regarding medical reports, because we are lawyers, we're not medical professions, but we understand that there is a deliberate policy of medical neglect for Palestinian prisoners. With this, I will focus a bit with all the pessimistic stuff that I shared with you. It's important to focus on what can we do. Because in military courts, with all honesty, there's no genuine justice or accountability for what the Israeli occupation does, or true justice for the Palestinians being prosecuted in military courts. So we don't go into the judicial system expecting any true justice for Palestinians. It's just a method that we have to partake in order to exhaust all the national remedies that are provided for us. What I mean by this is for example, the use of systematic torture and ill treatment against Palestinians, especially during interrogation. I would mention one case and show you how the advocacy work that we do tries to engage with UN procedures and other actors that could also and have the obligation to protect Palestinian rights. One case is the case of Samer al-Arbid, who was arrested in 2019. He was arrested in August 2019, to be more specific. And within 48 hours in interrogation in Al-Maskoubiya detention center in Jerusalem, he was transferred to a hospital where he had broken ribs and physical beatings or apparent physical beatings all across his bodies. But what makes his case even more hurtful or more bizarre is that the Israeli, that he was living for a whole week on ventilation, on systems that helped him live. So as Addameer, we filed a torture complaint in the Israeli investigative body that looks into the mistreatment or the bad treatment of Israeli interrogators of detainees. And a year later, that file was closed due to lack of efficient evidence that torture was used. Although this prisoner was transferred to a hospital within 48 hours after interrogation with clear bruises and physical beatings on him, and he was living on ventilation for a whole week. So if we want to talk about accountability for Israeli interrogators, that doesn't exist in where we are. So we do advocacy work with the United Nations, where there is the Committee Against Torture. There is the Special Rapporteur Against Torture and Ill Treatment in the UN Special Procedures, where we report on the testimony of the prisoner and we share it to the working group, we share it to the special procedures. And what we gain from that, because as much as I love international law and I'm a very strong believer in international law, I understand the incapabilities of international law, because the United Nations will not come to Palestine and get the detainees out or hold the Israeli interrogators responsible or accountable. But what they can do to help us is they provide legal opinions that become credible sources that what happened to this prisoner is torture and does amount to torture. So when we go to the International Criminal Court and report that Israel uses systematic torture against Palestinians, we do not only have documentation from Addameer, that is a Palestinian organization, we also have documentation and legal procedures from the United Nations as well. And we work in direct communication with the Working Group on Arbitrary Detention in the United Nations, where they have certain requirements and laws and certain points that need to be met to call this arbitrary detention. So most of the cases that we follow up on, we always try our best to also report to the Working Group on Arbitrary Detention, because their opinion to us matters. It matters to the international community as well. So that's a bit on torture, but to finalize more on torture and why I say where we are now, we cannot have true justice, because Israeli law does say torture is prohibited. However, the Israeli High Court, in a decision in 1999, they judged that using moderated physical force against detainees in interrogation is accepted when there is a necessity defense. Of course, if you know international law, torture is absolutely prohibited. There is no situation where torture could be used against a person. But we see Israeli judicial precedents say that, yes, interrogators could use torture when there is a ticking bomb scenario. And I don't mean literally a ticking bomb scenario. I mean it is a necessity defense that they allow interrogators to use torture against the detainees. So the law is built really against us. There's no way to work against it in Israeli law and Israeli military orders. With that, I would move a bit to more about how we work and what we do.
Can you hear me? Just a second. We are at a 20-minute mark, so I'm hoping we can you can continue during the question and answer session. We'll hear from you at that point, but we are very strict because we need to stay on track. So forgive me for that, but we'll hear from you more in about 20 minutes. And thank you for understanding. And at this point, I'm inviting Professor Michael Strauss to this podium, and a quick introduction. Dr. Strauss is a professor of international law, international relations, and at the Center for Diplomatic and Strategic Studies in Paris. He is a consultant to the United States Special Rapporteur on Unilateral Coercive Measures and Human Rights. He is also the author of various legal publications, including 3 books, such as The Leasing of the Guantanamo Bay, The Viability of Territorial Leases in Resolving International Sovereignty Disputes, and Territorial Leasing and Diplomacy and International Law. Formerly, Professor Strauss worked as a journalist focusing on international relations.
Thank you. And I want to thank the center and everybody involved with it in the organization of this and for the invitation. It's been a marvelous conference so far. I hope my little contribution will contribute positively to it. Again, I want to start by saying thanks. No, I don't. I want to start by figuring out how to see my slides so I can move them. Is there...
So here's the, I'm just going to ask the RIT to put the slides up, and
So I'll see them here, or do I have? Okay, and I move them like this. Okay. Well, I hope to. I hope I can live up to the quality of the two previous presentations, because they set up rather nicely the kinds of things that I'm going to be talking about, which are effectively POWs, torture, and the big question of accountability in modern armed conflict. No, okay. I've highlighted some things here in the Third Geneva Convention, just so that we're all on the same page. And this is essentially how prisoners of war shall be treated. Article 3 says they should be treated humanely, and it sets forth the acts that should be prohibited, that shall be prohibited, including torture. I won't present too much of the Third Geneva Conventions, because as has already been said, one could probably speak all month about it and not get through it. But I'll just highlight a couple of things that are relevant to this situation involving the POWs in Artsakh. No, it's here. Okay. Article 13 of the Third Geneva Convention says that prisoners of war must at all times be humanely treated. Okay. These are pretty straightforward instructions to the world community and to the administrators of prisons, whether they be military or civilian, that prisoners of war have to be treated according to certain rules. There are certain things you cannot do because they are hors combat, or the combat. There are certain things that you must positively do in order to comply with the Third Geneva Convention in terms of how you treat them. These are some of the prohibitions in Article 17, which I believe was one of the ones that was mentioned earlier. No physical or mental torture, nor any other form of coercion may be inflicted on prisoners of war to secure from them information of any kind whatsoever. Now, lawyers are lawyers. Certainly there will be some that say, okay, well, if the condition is that you're trying to secure information from them, if you're not trying to secure information from them, it's okay to torture. No, it's not, of course, because there is also the Convention Against Torture that has existed since 1984. And as we just heard, that is pretty high up in the hierarchy of international law. In other words, whenever there is a conflict of laws, because international law has become such a broad field that sometimes elements of it do conflict with other elements of it. But the Convention Against Torture is generally considered at the top level, which is you never derogate from that. You cannot torture people. That's clear, no matter what else may happen in conflict with the laws. And it is important here because it defines what torture is. Any act by which severe pain or suffering, whether physical or mental, intentionally inflicted. Now, some countries, like the United States, signed this convention with reservation, and the reservation said, okay, we will accept being a party to this convention, but it allowed itself to define torture in its way. When international conventions are signed, it is very typical for countries to agree to 90, 95, maybe 98% of it, but include in their signature a reservation saying, okay, this applies, but we reserve the right to interpret something our particular way. Article 2 of the Convention Against Torture says that no exceptional circumstances whatsoever may be invoked as a justification of torture, including war or the threat of war, or anything that comes out of war. This essentially says you can't torture POWs, even though it repeats things that are said elsewhere, like in the Third Geneva Convention. All of these things reinforce each other. They're complementary, they add a little bit, but the main core of it tends to be repetitive and reinforcing. So this becomes very strong international law. However, as we know, POWs do get tortured. Not just here, but here too, in the war of 2020. This is, in a way, describing the process, the problem, but it's also part of the problem. And the reason I call it part of the problem is that you see an article like this in the Armenian Weekly. You don't see an article like this in, say, the New York Times, Washington Post, other international newspapers or media. CNN probably didn't say anything about this on the 23rd of February because this, you know, there are competing things going on in the world, competing for people's attention. And here, this is important, but elsewhere, where it should be important, because a human life is a human life, it's not necessarily deemed as important as something happening to people more locally. So this is part of the problem. We're talking about it here. We're physically in a country that's involved in the situation. And yet, if you're in Japan or Bolivia or someplace else, my guess is that people have not been talking about the situation. They may not even know there are POWs arising from the 2020 war, much less that they shouldn't even be there anymore because of the agreement. But that's the situation we have. The other element of this is, if you notice the date before the war began in Ukraine. So very quickly, the world's attention, even if the world got wind of this through articles in the New York Times or the Washington Post or the Globe and Mail or something like that, even if the world knew about this on the 23rd, everybody's attention got distracted on the 24th. So this is the kind of thing that is part of the reality of the situation that we have to deal with and take into consideration. Anyway, there are, of course, global organizations, NGOs and others, including our gracious host of this conference, that perpetuate the presence of these problems. Human Rights Watch put out this information in its World Report, its latest version of it, detailing the situation. And you also have a mention of the fact that not everybody is always clean. Wars by nature are messy. And it takes a lot of organizational integrity as well as strong military command and other elements to make sure that everybody follows the rules all the time at every level. It's a very difficult thing to achieve. But many of you, if not all of you, are aware of this report, which is a very comprehensive report. I will just highlight one thing from it here. Prohibited means employed during the questioning. Well, torture is mentioned, of course. That is, we have the de facto situation of the POWs still being POWs. That is a situation that sort of serves as the base for what can happen to them in detention. Obviously, torture is prohibited, but it is existing. So we have this situation. Is this a unique situation, though? Probably not. It is one that has most likely occurred in military conflicts throughout history. Torture, particularly when it's known about, sends a signal to the population of the opposing side. It affects morale, it affects the morale of the population, it affects the will to fight. Nonetheless, even though this stuff is going on and has gone on, there is probably less of it today in the world, thanks to things like the Geneva Conventions, thanks to the Convention Against Torture, and thanks to noble groups like this one that actively work to expose the situation to the public, put pressure on governments, and it's probably never going to get to zero torture, but we're a lot closer to that than we might have been without all of these things happening. Now, accountability. This is where the real problem comes in, because holding people accountable, holding states or governments accountable for the mistreatment of POWs, whether it's torture or anything else, whether it's even just keeping them as POWs, is a very, very difficult thing, in part because of some of the things that were mentioned yesterday. You need hard evidence, and particularly if POWs are kept in secret, and you don't even admit to the presence of the places where they are being kept, which was more or less the situation with the black sites that the United States CIA had early in its war on terror. It becomes very difficult to gather the evidence necessary to launch any kind of prosecution that will result in accountability taking a very concrete form, with people being held accountable, states, governments being held accountable, and some sort of consequences for their actions. We heard just a little bit earlier about POWs being put on trial. And in fact, we heard that they cannot be put on trial simply for fighting as part of an armed force. They can be charged and prosecuted if they are accused, formally accused, of committing war crimes, crimes against humanity, things like that. But under normal circumstances, if you're simply fighting in an armed force, you can't be put on trial. Or let me put it this way. If you are put on trial for that, it's illegal, because as we see, it does happen. Now, there are various paths that are developing for accountability when it comes to things like torture and other mistreatment of POWs. You have national courts, you have the International Criminal Court, you have the ICJ, which is being called upon to a certain extent in this case. You have the possibility of special tribunals. There are various options that have been developing. National courts, none of these options are perfect. and they're all still developing. I've highlighted a couple of things here with respect to Abu Ghraib, the torture that occurred there. Everybody knows it happened. And some people probably remember the names of some of the soldiers that were, the military people that were prosecuted for it. But what about high-level officials that allowed it to happen, or maybe were complicit in some respect with it? That's a lot more difficult. You have the ICC. Again, still a work in progress when it comes to developing its authority on a global basis for determining accountability. And you have the ICJ, which in this case highlights something very useful and interesting to know, and that is that the ICJ was called upon in connection with the Artsakh situation regarding POWs through a relatively creative use of the International Convention Against Discrimination. The POWs happen to be Armenians. Their treatment in various respects is considered discrimination, including the torture against the POWs. So it's a broader thing that encompasses the torture. So there's a bit of creativity, and that may be necessary. This is just to show that it's not a new situation. The lack of accountability for torture of POWs in wartime goes back. It's a very difficult thing to eradicate. However, we can take some comfort in the fact today that because of the Geneva Convention, the Third Geneva Convention, because of the Convention Against Torture, we're beginning to have the structure of accountability gel. Everything is still relatively new in terms of world history, in terms of the history of armed conflict, but we now have these legal instruments in place. We also now have some of the legal mechanisms in place that I mentioned earlier, the ICJ, the ICC. But these are still, particularly the ICC, very recent. They're still developing their track record. And in a way, that can be a good thing because it means that there aren't enough wars to really have a firm body of practice and judgments to guide what future judgments will be. At the same time, the fact that it's still developing may mean that the war of 2020 happened too soon for the process of accountability to really be firmly established. And it is very clearly an area of international law that needs developing because it has a ton of questions. Who is accountable in a certain circumstance? Is it the state? Is it the political leadership? Is it the military leadership? Is it the people who actively carry out the torture themselves with their own hands? Is it the enterprise that provides electricity to the prison where the torture is carried out? All of these questions is just one area. Another area is accountable to whom or to what? To the victims, to the state where the victims are from, to the international community, to an international institution of some sort, and for what acts, and how can you prove it? What evidence? What is the basis for proof? What are the standards of evidence that are acceptable? As I mentioned, secret prisons, black sites make it very, very difficult. And one other unknown that may play into this is, what do the victims want? Those victims may not necessarily think the same way as the prosecutors or even the populations from where they come from. I was with last week 3 former prisoners at Guantanamo who had undergone torture. One of them is a Moroccan who is now back in Morocco. All 3 were released because of they were determined to be innocent. They were there because various reasons, bounties and other things. One of them is back in Morocco. He was a chef before his capture, and he returned to being a chef at a restaurant after he was released. He is now the owner of a relatively new restaurant in Tangier, and he holds no grudge against those who imprisoned him and those who tortured him because of his belief that these people didn't necessarily have a whole lot of choice in what they did. Of course, everybody has choices in life. You could choose to resign from the army and face perhaps punishment for not doing what you're assigned. Nonetheless, he felt, okay, he said he would welcome anybody who was involved in his treatment in the prison at Guantanamo to have a meal at his restaurant with his pleasure, and he would treat them royally, just to show that human beings ultimately are human beings. So the question of what victims want come into it too. Anyway, I think I will end here because actually that is the end of what I presented. It doesn't always work out that way to exactly 20 minutes, but I think it did this time. So thank you very much once again. I stand ready to answer questions, and we'll leave it there.
Thank you so much, Professor Strauss. And we're now here for the continuation of a good time and for a question and answer session. We have quite a bit of questions to all of you. We'll start with Ms. Ansari. We talked about that there is a number of oppressive regimes that condone this type of illegal detention. We have this in Palestine, we have this in Azerbaijan. How do we make a change, and what are the advocacy strategies that Addameer can share with us over the years that you see as yielding some change?
Emilia, thank you for the question. I mean, I will be very specific how Addameer does advocacy work, and it does differentiate between one case to another, depending on who are the targeted actors that we want them to take action. So for example, when I want to stay away from torture, but it's a good example of how advocacy works. So for torture, since it is an ongoing occupation and settler colonial regime, it's very difficult to start looking at, and I'll continue from where Professor Michael left off, like accountability or remedies. At this point, we are, for torture violations, we are looking for any actor that can give us a legal procedure or a legal document that clearly says what's happening on ground is torture. So we look at accountability in different stages. For detainees that are on a hunger strike, for example, there is a really important need to act very quickly and act sufficiently. So usually during these cases, we do advocacy that targets all actors. So it is the United Nations, it is the representative offices that we meet with in Palestine, in Ramallah. It is the international community and the people of consciousness. So also social media plays a huge role in advocacy, whether we like it or not. There should always be that highlighted awareness about what's going on in Palestine and how you can act. So it differentiates on a case-by-case basis and what systematic policies are we targeting, whether we want on the longer run conclusions or goals, or whether right now there's a person on a hunger strike who's detained without charges, without any trial going on. So we need people to act now. So more importantly, we focus on the people to put pressure on their own governments as well. And this has helped a lot with advocacy. So if it's students being arrested, we always connect with the legal the political or the diplomatic representatives in Palestine. There's always a need to activate all actors that have a role. But most importantly, we try to connect the policy to the root cause of why the prisoners are in prison, because usually it's difficult to activate the international community on the root causes. So we try as much as possible to remind people that hunger strikes will continue on coming and will continue on emerging as long as administrative detention, which is detention without trial, without charges, continue to become a systematic policy. For example, it's very important for us to engage with the Human Rights Council at the United Nations, where the special procedures there has a credible reporting and conclusions and recommendations to states. So for example, the Committee Against Torture, or let me go to the CCPR, the Civil and Political Rights Committee. Last year, they had a review for Israel regarding their respect of the CCPR Convention. So we were reporting with alternative reports from civil society how Israel violates this. So it's always important to activate all procedures that are mandated to follow up on these cases. So with advocacy, it's on a case-by-case basis, depending on the conditions of arrest, what policies were made, but it's always three actors that we focus on. The more formal level, which is the United Nations, and the political level, which is diplomats, and diplomats play a really important role because governments also play a role in putting pressure on the Israeli occupation and trying to hold it accountable. And then we have grassroots organizations, international non-governmental organizations. I won't take long, I'm sorry, but I would link to Human Rights Watch because Professor Michael just mentioned it. So for example, Human Rights Watch and Amnesty International, the past few months have submitted their reports that recognize Israel as an apartheid regime based on their own legal analysis that is based on reportings from Palestinian civil society. So the work that we have been doing for 5 years, making it clear the violations that Israel does on ground amounts to apartheid, has been heard by international organizations, and it does change the dynamics in the international community, and this has been really helpful. And with South Africa's government stating that we see what's happening and we do recognize it as well as apartheid, this as a political aspect also plays an important role in the advocacy work that we do.
Thank you, Ms. Ansari, for a comprehensive response. Our next question is about the Committee Against Torture. What is the turnaround time for processing claims, and what kind of force do recommendations issued by this committee have? Is there any enforceability issues that are attaching to their recommendations? And this question is not addressed to anybody else, so I'm inviting our panelists to respond. Professor Grignon.
Okay, thank you. So if I understood well, the question is how can you fill in a communication to the Committee Against Torture in order to make a state accountable for acts of torture or ill treatment. So you have first to bring your case in front of a national court, And then if you don't succeed in front of national courts, then you can ask the Committee Against Torture to look at your case if the state is a party to the Convention Against Torture of 1984, the United Nations one. Then the committee will look at your communication. We say communication in the United Nations system, and it answers the second part of the question about the force or the constraint the recommendations of the committee may have afterwards. And Philippe Larochelle spoke about Boily, a case that he has followed in front of the Committee Against Torture, and he explained that even if the CAT gives a decision in order not to deport someone because this person could face torture, for example, then sometimes states don't respect the decision of the committee. But that's the same thing for everything in international law, because we don't have an international police to enforce the decisions of international bodies. I would just end my answer with flagging that there is like a controversy within the international community about the enforcement of decisions from committees within the United Nations. For some states, those recommendations are not binding. For example, a decision from the European Court of Human Rights would be binding, but not the decision of the Committee Against Torture for that same case. But for other states, they have, they understand the decisions of the committee as being binding upon them. So it depends, and there is a debate currently in the international community.
Thank you so much, Professor. Our next question is directed to Professor Michael Strauss. And given your experience as a consultant to the UN Special Rapporteur on unilateral coercive measures and human rights, what actions do you think we should take for Artsakh? Further, what do you think about the prospect of creating a commission of inquiry or some type of political investigative mechanism for Artsakh?
Okay, thank you for the question. As a consultant to the UN, I deal with economic sanctions. Unilateral coercive measures is a relatively undefined phrase. We've heard earlier about the importance of legal definitions of what we're talking about, whether it's genocide, whether it's torture. Unilateral coercive measures remains undefined, even though there have been resolutions declaring them to be illegal. They're generally considered to include economic sanctions, but they theoretically could include other forms of coercion taken by unilateral actors. Indeed, even unilateral is not entirely defined, because does the European Union count as a unilateral actor in this sense? We consider it in that sense, but maybe not everybody does. I'm not too sure whether economic sanctions would be the appropriate means to deal with a situation like Artsakh. In part because we are finding, and this is part of my work, we are finding that economic sanctions, even when targeted, inadvertently create their own human rights problems. If you consider economic sanctions to be a substitute for any kind of due process, particularly when imposed against entities, governments, individuals abroad, these are generally substitutes for due process. Due process procedures, if they were carried out, would determine whether the party is innocent or guilty. And if guilty, then there would be procedures to deal with that. But when it comes to unilateral coercive measures, they are quite often taken because they're faster, they are politically very satisfying to the country imposing them, because the government has the appearance of acting against a problem, but by and large, they're not really very effective. And we can see this with the sanctions that are probably stronger than any sanctions have ever been against Russia because of the actions in Ukraine. The sanctions against Russia after 2014, when it annexed Crimea, did not cause it to give Crimea back to Ukraine. Now these further sanctions are so far not having the desired impact, but they do satisfy a certain degree of public desire to do something, and it's quick and it's dramatic. So, but you can see they themselves are creating some human rights problems for people who cannot transfer money for their education, Russian students abroad, for example, all sorts of things like that that are unintended. So we're trying to work out what these problems are, so that perhaps sanctions can be improved one day so that they don't, and maybe at that point, they would be recommendable in a situation like this. Let's hope the situation doesn't last until then, because I don't think they'll be at that point anytime soon, but we're working. In terms of a commission of inquiry, I generally think that those things are good, provided that they are constituted well and have a good framework for frame of reference for their tasks, because any information about even before you determine guilt or innocence, any information that comes out is going to be useful. It is going to inform future situations, and it will guide how the situation at hand can be dealt with, even if there's no ultimate firm judgment on the basis of it. But there might be. It all depends on what the tasks of the commission might be. But I tend to favor things like that. I mean, information about anything is never wasted. It's always useful. And so much information is so hard to get anyway, that one in this situation, commission of inquiry in this situation, yeah, I'm for it.
Thank you, Professor. And if there's any other feedback about fact-finding commissions, our panelists can join. And we have another question, actually. Go ahead.
Sorry, it's very quick, but just to mention that, yes, commission of inquiries could definitely be helpful regarding collecting information from a third aspect of whatever conflict or situation there is. So, for example, in Palestine, we recently, the United Nations has brought up the commission of inquiry in the root causes of the situation in Palestine. And we have welcomed this commission inquiry very warmly, because it does try to look into what the root causes are, what the problem is here. And it's always good to report with these commission of inquiries, because at the end of the day, it is in a way a third eye that's looking on the situation on ground. So hopefully without any political pressure or political influence.
Thank you. Our next question is concerning the circumstantial evidence that is pretty strong that Azerbaijan may be holding a number of prisoners of war that Azerbaijan refuses to acknowledge. Is there any recourse for that? Is there any legal or quasi-legal mechanism to at least have Azerbaijan acknowledge the existence of those prisoners of war?
You want me to answer that question?
Please, please.
So unfortunately, under IHL, we do not have a mechanism to implement or to monitor the application of international humanitarian law. So you have other judicial bodies like European Court of Human Rights, for example, which can have a look to the implementation of international humanitarian law. But we have also to be conscious that IHL has to be applied during armed conflict. And yes, we have to try those who do not respect IHL, but also we have to advocate for the application of IHL during armed conflict. And here you have to negotiate, you have to discuss with all the parties to the conflict to obtain respect for IHL. And one organization, it has been said earlier, the guardian of international humanitarian law, the ICRC, is the organization with which you can have a confidential discussion in order to achieve respect for IHL. But as I have just said, the ICRC is working on a confidential basis in order to keep access to all those who are detained during armed conflict. And sometimes we don't know what they are doing in order to access these prisoners and what they do in order to obtain their release and repatriation, for example. But they are in the field and they are working to that purpose.
Thank you, Professor. Our next question deals with a problematic situation concerning POWs held in Azerbaijan. Some of them were put through sham trials, as we discussed earlier today, and were sentenced to some of them up to 20 years. Some had a lesser sentence. And given the fact that the Azerbaijani regime is very oppressive and they don't allow advocacy groups necessarily, or Armenian advocacy groups are not allowed in there, is there a possibility to advocate on behalf of those imprisoned from outside of Azerbaijan, given that we don't have access necessarily to these POWs to obtain consent to represent them? And I'm referring to legal, quasi-legal mechanisms that you can think of.
Again, that's a very difficult question because, as also the other panelists said, this is also a very political question. So you have the answer of the law, but then to enforce the law, you have to deal with politics. So an event like this conference is a way to advocate for prisoners being held in Azerbaijan currently. So you have to use all channels to raise attention about these prisoners and trying to obtain their release and repatriation, and also to check whether the prosecutions they faced were in conformity with judicial guarantees. And you were speaking about the sentence of 20 years, for example. So I'm not a specialist of criminal law, but it may seem disproportionate to receive such a sentence. And then, yes, even Armenia with Azerbaijan in their negotiation can negotiate about the sentence. Or I dealt with the exchange of prisoners, for example, and it could be something in the negotiation to repatriate prisoners before the end of their sentence.
Thank you, Professor. Another question concerns the statements made by the Turkish leadership, Erdogan, and Azerbaijani leadership, President Aliyev, concerning the fact that they intend to use POWs as a negotiations tool and force certain concessions upon Armenia. Is there anything that is legally or otherwise available as an option against this kind of abuse?
Again, exchange of prisoners are not dealt with in the Third Geneva Convention, but parties to a conflict may agree among themselves about release and repatriation in exchange of anything they want to negotiate. But what we should keep in mind here is that a human being should not be exchanged for political purposes, for example. So you have to monitor that situation. But again, that's not, I think that the answer is not within the law, but within politics again.
Understood. And if other panelists have anything to add to this, please.
Yeah, I would agree with that. It seems that the most expedient route to resolve a situation like this is to somehow make it politically or economically or in some other way attractive or worthwhile for Azerbaijan to do this. Right now, it obviously does not feel like it would have any particular benefit from doing it. In fact, the benefit it presumably perceives is comes from continuing to hold the POWs. So that is the calculus that has to change. And I think that would come from outside the law and more from politics or economics, looking for weaknesses that can be addressed with a carrot to induce their change of conduct.
Thank you, Arnal. Milena, do you have anything to add? I think we will have a consensus on that. And our last question for today, it pertains to UN. And we had a discussion earlier today, but this specific question is as follows. Many of you discussed the importance of UN avenues, but oftentimes it is hard to even get to the UN, get the UN to take a position or say something that might be valuable for advocacy purposes. How can we get around the geopolitical influences that still find their way to impede UN actions in a setting that is, at least idealistically, supposed to be void of that influence?
It's always difficult to get the UN moving, but that doesn't mean that we should give up on it as a platform that does provide some kind of procedures or reporting or documentation. So what I would say is also there's a need to have good connections with specific actors in the United Nations. I mean, I know we're saying pessimistic things a bit, but even me as a Palestinian and as a Palestinian lawyer, I do value the work of the United Nations, especially the special procedures. Like, regardless of what we hear, that it's difficult to get them to publish a statement or highlight a certain situation, but it takes time. This is international law. We need to keep on reporting and not give up on it as a solution. And trust me, I'm saying this as a Palestinian, where we've been talking about apartheid the past 5 years, and we've had harassments as Palestinian organizations, like, what are you saying, apartheid? That's not true. And we had, during the Human Rights Council, our time taken from us for saying apartheid. But now we are seeing statements from the United Nations Special Procedures. We are seeing the UN Special Rapporteur Mikaelian talk when he was finishing up his mandate regarding the situation of human rights in Palestine, submitted a report that said clearly on apartheid. And then there's always a link with special rapporteurs. Like, if a case is about a female detainee or a female prisoner, we always have to include, for example, the Special Rapporteur on Palestine, the Special Rapporteur on the elimination of discrimination against women, the Special Rapporteur on health. So it's always important to be inclusive with all the United Nations bodies and mechanisms, and keep on doing what you do, because it takes time, it takes frustration, but it is a venue that we all need and respect and in a way trust. So I think that would be a more positive answer and a more optimistic answer to that.
Thank you, Milena. Yep. Professor, please add.
Yes, I can add to that. I certainly agree with that. And also, once again, it's like international law in general. It's very imperfect. It's always evolving in one way or another. Politics heavily influences what comes out at the other end, but situations would be probably worse if it didn't exist. One thing that does result from the United Nations, even if you don't get final results on a situation in a very satisfying way as quickly as you might want, it does serve and provide a platform for publicizing situations through the reports that it puts out, through the Human Rights Council and the General Assembly. The United Nations produces an enormous amount of information that then becomes useful in other circumstances that may be able to take the situation forward faster or more efficiently or better in some way than the United Nations itself might be able to. The other thing is that countries at the receiving end that don't necessarily like what the United Nations is doing in a particular circumstance, they may find themselves on in the minority of member states voting on a resolution or something like that. They nonetheless pay attention to these outcomes. All countries pay attention to what the United Nations does. They take it into account. They may not respond overtly or immediately or at all, but it provides countries with an opportunity to respond to situations. And I think perhaps the most telling endorsement in a way of the United Nations, even from countries that may have on the surface look like they give up on it, is the fact that nobody quits. Everybody's still a member. Whenever there is a new state formed, first thing they do is they apply for membership in the United Nations. It gives them a platform, but it also serves as a very useful instrument, imperfect as it is, in these various ways.
Thank you, Professor. And I want to thank our amazing panelists today on behalf of our CFTJ, Professor Strauss for being here in person, Professor Grignon from joining all the way from Geneva, and Ms. Ansari all the way from Ramallah. This was a very rich and important conversation, and we definitely look forward for more. Thank you again.